under threat of congressional subpoena, this represents an abuse of congressional power. The Oversight and Government Reform Committee, of which I'm a member, one of the senior Democrats, in this case the majority, by requesting documents from the NLRB on this case, has orchestrated a public cross-examination of Boeing's top lawyer, of the board's top lawyer, in an effort to force him to expose his legal theory publicly. Just think about that. You know, they're preparing their case based on their investigation, and some members of Congress are intervening to try to find out what the strategy is. Who does that benefit? And the majority on the Oversight Committee has even threatened to hold staff attorneys at the National Labor Relations Board in contempt of Congress if they don't publicly reveal their strategy. Warning of severe consequences, which would follow if the attorneys at the board don't comply, including bringing the lawyers, get this, to the attention of bar licensing associations. There's something critical at stake in the outcome of the vote on this legislation. The prospect of subverting the American system of due process and justice for workers whose rights have been violated. This is really a question of due process. You know, the National Labor Relations Act sets up a series of steps that have to be taken to determine if there's a violation, and then there has to be a remedy. This legislation just seeks to subvert that. The bill weakens the authority of the National Labor Relations Act by stripping Section 10C of the Act and inserting the following language, provided further, I'm quoting from this bill, that the board shall have no power to order an employer, parentheses, or seek an order against an employer, close parentheses, to restore or reinstate any work, product, production line, or equipment, to rescind any relocation, transfer, subcontracting, outsourcing, or other change regarding the location, entity, or persons who shall be engaged in production or other business operations, or require any employer to make an initial or additional investment in any particular plant, facility, or location. So where's the remedy that workers would have? Not just in Boeing, anywhere. This goes to the heart of what the National Labor Relations Act is all about. In addition, the legislation would apply to any complaint for which a final adjudication has not been made as of the date of enactment. Namely, this goes after the NLRB proceeding with respect to Boeing. Now, a little bit of background on this NLRB complaint. In June of this year, the NLRB commenced an enforcement action against Boeing based on a claim by the International Association of Machinists District 751, which is part of the International Association of Machinists and Aerospace Workers, that Boeing broke worker protection laws when it told unionized workers in Everett, Washington, that it would transfer airplane assembly to its newly non-union facility in Charleston, South Carolina, due to past and future union activity. The complaint alleges, the NLRB's complaint alleges, that Boeing's motive for the transfer of work to escape and to suppress lawful concerted activity of its workers, that in fact was unlawful and violated the National Labor Relations Act. The complaint relies upon videotaped statements and statements in public shareholder conferences in which Boeing's top executives admitted, it's on videotape, admitted that the overriding factor for the decision to transfer the work was the past and possible future strike activity of the workforce. Sometimes the board uses its power to demand a remedy from employers that really changes things. You can order an employer not just to post a notice, but put things back the way they were before the unlawful action was committed. This means in order to enforce what's called the status quo ante. After the board issues this type of order, it can be enforced in federal court. Here, the status quo ante would require Boeing to halt its unlawful transfer of work from the Everett plant to Charleston. Now, this kind of remedy would be to challenge what a corporation did in violation of the law, because that corporation has to genuinely undo the damage it caused and give up the benefit unlawfully obtained. It's not a problem. It can be finessed merely by throwing more money and lawyers at it. This pain is only going to stop if the corporation complies with the law. Most NLRB complaints are resolved by a settlement among the parties, as Boeing and the NLRB are keenly aware. Bear in mind that Boeing is already building a second assembly line in Washington State. I mean, Boeing could have settled this matter months ago. So, any other questions of myself or any of the other panelists here? Anyone? We will keep, if you sign up the list, we'll keep you posted as we learn the legislation is about to move to the floor. This is one of the most significant pieces of legislation relating to workers' rights that has come before this Congress in a long time. And we need to make sure we get the word out, which is why this is the first of many different discussions we're having before the legislation is brought forward. I ask those who are congressional staffers here to take this information back to your staff member, and I'll be happy to talk to them further about it on the floor of the House. Thanks, everyone.